We are continuing our discussion this morning on the appeal court's decision that former Chief Magistrate Marcia Ayers was forced out of office. Today we examine the significance of the ruling and its possible impact on the judiciary. Joining us now is Attorney at Law Martin George. Mr. George, good morning.
Yeah, hi. Good morning to you, Marlon, and good morning to your viewers on TV6.
Of course, and Mr. George, let me say it's always good to speak with you. Every time we call on you to speak, you have not denied us, so we do appreciate that. But let's look at this ruling, Mr. George. Let's also look at the significance of it. I suspect there's a perception that some people believe that this is just a row between an employer and an employee. So let's look at the impact, if any, it may have on the judiciary. Yeah,
so Marlon, first we have to understand that this was a very strong Court of Appeal bench comprising of Justices of Appeal Mendonça, Barrow, and Suhan. So their decision must be given the utmost respect. However, Marlon, the beauty of the law is that there's always the possibility of looking at things from a different perspective. Now, this Court of Appeal held that the Judicial and Legal Services Commission was wrong to have basically coerced a sitting judge out of office by offering her the option of resigning, and if she did not resign, they basically said, there's the or else. We will institute disciplinary proceedings against you. So this was kind of like the old carrot and stick approach. The carrot being resign and save your dignity, the stick being if you don't resign, disciplinary proceedings are coming. And of course, one can imagine the fallout from that for a judge, sitting, and facing disciplinary proceedings. Of course, that would make news, and of course, there would be a whole public furor over that. So that was the scenario in which the Court of Appeal found that the actions of the Judicial and Legal Services Commission, they were saying that they were wrong to do so, because they were saying that basically this was an attempt to force or coerce her out of office. For her part, Justice Marcia Ayers said that this did amount to undue pressure on her, and she felt forced and coerced out of office. And the Court of Appeal held that the net effect of this action was that Justice Marcia Ayers was removed as a judge, contrary to the provisions of Section 137 of the Constitution. So, the Court of Appeal basically ruled that the JLSC, the Judicial and Legal Services Commission, was wrong to do so. And then they went on to say that, look, Justice Marcia Ayers was right in her claim that she was forced out of office. Now, and this is the thing that makes the law so exciting and engaging, Marlon. The Court of Appeal basically said, by the JLSC being wrong, they then went on to say Justice Marcia Ayers is right. But, I'm wondering, Marlon, is there another possibility lurking in the shadows? In other words, is there a thin sliver of an alternative view which can slice through like a scalpel through this right or wrong situation to say, wait, is there another possibility that can be found here? The question being, is it possible that you can find the actions of the JLSC may be wrong if it is that their intention was to coerce and force her out of office, right? Which the Court of Appeal clearly seemed to be of that view. So that's fine. They can make that finding. But does that automatically equate to Justice Marcia Ayers being right? Because that's where I have some questions, Marlon.
Yes.
And I want the public to understand what is at play here. In her claim, this is a scenario where Justice Marcia Ayers tendered her resignation. She was a former Chief Magistrate who served for several years with distinction. She was a former attorney at law. She's now appointed as a High Court judge. This is no ordinary Tom, Dick, or Harry Lala. This is a trained attorney, a trained magistrate, a trained and experienced former Chief Magistrate who would have sat on some of the most complex, rigorous, and arduous cases. So it is inconceivable to see a scenario where you can say that your will can be so easily bent by someone saying, well, if you don't resign, we'll institute disciplinary proceedings. Listen, the fact of the matter is that disciplinary proceedings are instituted against judicial officers, more frequently than the public may even know or imagine. So it's not to say that that is something that you ought to be afraid of or say that, well, look, as a result of that, I am forced to resign. In fact, you would ask yourself, where's that strong and robust independence that one would expect from a former chief magistrate? Where's that confidence in the security of tenure, which every sitting judge knows that they have?
But then at the end of the day, you can also ask, Mr. George, that at the end of the day, a man is just a man, a woman is just a woman.
Yes, but the point is, this is no ordinary man or no ordinary woman.
Yeah.
You are a former chief magistrate. So in other words, all the magisterial districts throughout Trinidad and Tobago, you are in charge of all the magistrates. You sit on the most complex cases that come to the magistracy. You've now been elevated to the level of a judge. So therefore, you must be viewed differently. And that is the fact of the matter. And in fact, if you look at it, Marlon, some of the very arguments that I've seen advanced on her behalf can in fact turn out to be a two-edged sword, which can cut both ways. Because if you are saying in your arguments that a judge cannot be removed except by the proper application of the provisions of Section 137 of the Constitution, then you as a judge must be acutely aware of that. So therefore, when they come with this, ill-conceived attempt at coercion to try to coerce you out of office with this threat of disciplinary proceedings, you're supposed to tell them, hey, listen, I know my rights. You can't move me just so you do what you want. If you understand me.
Yes,
so therefore, how could you now say that you were so troubled by this, that this now cowed you into submission and made you, retreat into a corner and sit down and, start writing your resignation letter because you felt you had no choice and you were so intimidated? Come on. As a chief magistrate, you can't be so easily intimidated or so easily pressured, because as a judge, as a judicial officer, listen, people come at you from all sides. You are dealing with attorneys who are arguing strenuously from opposite sides of an equation. You have to be able to be robustly independent and strong enough. In fact, you're supposed to have that strength of mind, that strength of will, that strength of character, that even in the face of whatever, you are supposed to make your own independent decision.
Well, Mr. George, as you know,
when they came with this supposed poison porn offer of resign or else, you knowing your rights and knowing that you cannot be removed. So the very same argument that they are using can turn out to be an argument whereby she can end up being hoisted upon her own petard, depending on how the Privy Council looks at it, if it goes there.
Of course,
right?
and that's my next point, in that the matter is not yet complete. There's a possibility of appeal, I suspect. But, Mr. George, since the ruling, since the judgment of a few days ago, we have not heard a word from the Judiciary, the JLSC, the Chief Justice. Do you think that the Chief Justice or the JLSC, as headed by him, needs to say something?
Well, I would imagine in due course they would. At this point, it may be just a case of them keeping their powder dry and looking at their options. Because, you see, if they do not appeal this, it really lays some fundamentals which they will find difficult to change thereafter. Of course, they have to weigh the option, well, hey, do we leave it and simply say, well, it's a Court of Appeal decision, it's not a Privy Council decision, or do they take the chance and move it forward and say, hey, listen, we feel confident enough at the Privy Council level that we will prevail, so therefore we want to get a ruling on this from the Privy Council. But I think for the sake of the nation, it ought to be escalated to the level of the Privy Council, and let's all have a final determination on the matter, because I think there's too much at stake here, Marlon. In other words, the question really comes down to, is it a scenario where you are saying that you did not know your rights, you did not know that you could stand your ground? And I mean, I'm not invoking any recent, connotations of that expression. But if you follow me, you basically could do a whole bagan for them and say, I'm not moving. You have precedent, you have cases, you have authorities. You have the matter of the former Justice Crane, where then Chief Justice Clinton Bernard sought to put pressure on him because of certain performance issues in terms of how Justice Crane was handling, or should I say not handling, his court matters. And Justice Crane fought back and stood his ground. So therefore you have plenty precedent. You even had a situation where a registrar of the High Court who felt that the then Chief Justice was trying to pressure her, and she took legal action. So as a sitting judge, I'm saying that you must have known of such matters. You must have known of the strength that you have in your security of tenure. So therefore, you cannot say lightly that you were so pressured or intimidated or cowed or, felt that, you had no other option. No, you had options. You had the option to say, hey, listen, I am staying here. You do what you wish. There is a procedure under Section 137. So the same argument that is being used on her behalf, as I say, could be an argument used against her.
Yeah,
right.
Mr. George.
So therefore, you ask yourself, even when you look, I saw some words quoted in the newspaper from a press conference given by her attorney over the weekend, where it was said she's a very strong-willed woman. So if you are a very strong-willed person, how come it is that you are claiming to be so easily intimidated and coerced by a person saying, well, we'll institute disciplinary proceedings?
Yeah, Mr. George, I think that we can agree that these are serious allegations. But I'm just wondering, since the ruling, what is the perception out there in Trinidad and Tobago, read the judiciary, by this ruling? And do you think that it has had an impact on the credibility of the JLSC, the integrity of the JLSC?
Well, I think certainly this ruling by the Court of Appeal definitely would have that impact. There's no doubt about it. And I think the man in the street would take it at face value and basically say, look, the Court of Appeal has ruled that the JLSC is wrong. It's not necessarily the first time that the JLSC has been wrong. So therefore, of course, that again goes to the whole question of the confidence in the entire judicial system. And I think that is another reason why they ought to consider very strongly the possibility of appealing this to the Privy Council. Because in the final analysis, Marlon, what I'm saying is that, look, there may be the possibility of not using the hammer here to smash things. In analyzing this, if you use a surgeon's scalpel with precision, you may be able to find this thin sliver between the wrong and the right. And it may be possible to find that even if the alleged coercive actions of the Judicial and Legal Service Commission were wrong, that doesn't automatically equate to the claim of Justice Marcia Ayers being right. In fact, you may find that it's possible that you could make a ruling that the JLSC might have been wrong, and also Justice Marcia Ayers was equally wrong, because she would have a hard time convincing the public and convincing, persons, maybe even at the Privy Council level, that she really was actually pressured. So in other words, okay, if they were wrong to attempt to pressure her, I think there's another step that seems to be missing here. Did that pressure actually be the trigger for a reasonable person in your circumstances, with your training, your knowledge, your experience? Was that pressure really the trigger for you tendering your resignation? And ought it to have been sufficient to pressure you to do so? In other words, you ought to have been able to stand up against that and say, hey, listen, from my years of training, my years of experience, my knowledge of the law, my knowledge of the cases, all the training I've done, and all the precedents I know of where other judges have been, put under pressure, or your registrar, as I say, the law is replete with cases and authorities in that regard. So therefore, the Privy Council, I think, I would love to see how they look at this matter and how they interpret it, because it may be that not necessarily that one party being wrong means the other one is right. It could very well be that they are both wrong in the circumstances, and I think a final determination by the Privy Council will be the only thing to resolve this.
There has also been a suggestion, Mr. George, that in light of the ruling, that maybe the Chief Magistrate needs to engage himself in more administrative matters than court matters because of this situation. You think that's premature?
Well, the thing is, I mean, it would apply not just to the post of the Chief Magistrate. I think.
Did I say Chief Magistrate? I meant Chief Justice.
Lamented repeatedly.
Mr. George, if I said Chief Magistrate, I meant Chief Justice.
Oh, right. Yes, yes. Well, in fact, I think that the present Chief Justice has lamented many times, I mean, his multidisciplinary portfolio, basically. He has judicial responsibilities, he has administrative responsibilities, he has financial accountability responsibilities. So it's really, difficult for one person to handle all of those things. In some other jurisdictions, they appoint like a chancellor, and stuff like that. So it might be something worth considering, because it really is quite a lot for one person to manage and to manage effectively. So, of course, but then this goes to the root of our constitutional foundation. So, therefore, you're talking constitutional reform in that regard.
No, but Mr. George, yes, I don't know that I made myself clear. I may have bungled what I was trying to say. But what I was saying, what I was trying to say, in light of this ruling and this dark cloud, if I can say that, if other persons have said that, because of this ruling, and the Chief Justice heads the JLSC. Because of this ruling, maybe he needs to adopt these administrative roles for now and step away from matters that he may have to preside over.
That's a different thing. That's an entirely different thing. I am not sure that it's necessarily merited in this scenario. I mean, if that were to be done, it would have been done quite some time ago, and it didn't happen then. I don't see it happening now, and quite frankly, I'm not sure it seems to be even merited in this circumstance, with the greatest of respect to, those who may have expressed that view.
Yeah.
Because this is a collective body, even though he heads the body, it's a collective body of, one would assume, fairly independent persons, and this is a body appointed by the president. So I'm not sure that it necessarily means that it extends to saying that, the Chief Justice ought not to preside on matters as a result of this ruling. Yeah. So I think that's a bit of overreach.
There was also a recent suggestion or concern that these senior judicial officers, and I'm speaking about the appeal court. You're hearing me? Yeah?
Oh, I'm hearing you now.
Yeah. There was also the view and a concern that that the relationship between the appeal court and the Chief Justice could now be a little shaky because of this ruling. It is being viewed in some quarters that these senior judicial officers have really gone against the Chief Justice.
Well, the point is, as a judge, you are supposed to be robustly independent, and you are supposed to rule based upon your interpretation, understanding, and analysis of the law and the facts before you, and let your decision come down and let the chips fall where they may. So, if it is that these three judges did so, then they did excellently well in the discharge of their judicial functions. They're not supposed to be similarly intimidated or cowed or, to say, well, because it's the Chief Justice involved and the Judicial Legal Services, Commission, therefore, we have to be careful how we make our ruling. The minute you start to do that, then your entire justice system is undermined and eroded. So if it is that they stood up robustly and independently and made their decision, then of course they are to be applauded and commended for that.
Yeah. So, Mr. George, you did allude to the fact that you believe that there is going to be an appeal and the matter may go straight to the Privy Council. But what do we do in the meantime?
Well, in the meantime, the fact of the matter is that the Court of Appeal basically has, given their decision, and in effect, it would mean that she basically would retain her standing as a sitting judge. No pun intended in that, apparent oxymoronic statement. But the reality is that if it is that the matter does go before the Privy Council, prudence would dictate that she would not seek to, try to enforce that right by way of saying, well, look, let me be assigned to sit on matters or sit on cases. The mature and reasonable and rational course of action would be that you would await the outcome of the decision of the Privy Council and respect the judicial process. So, I don't see any difficulty there, in that regard.
Yeah. Martin George, it's always a pleasure speaking with you. Thank you for the education this morning.
Marlon, if you're speaking, I'm not
Mr. George, you're hearing me? You're hearing me?
Marlon.
I'm just saying thank you. Thank you again.
Marlon.
Yes?
Your volume level is probably
So can you raise up my
low.
volume level so that Mr. George can hear me?
All right.
Yes. Mr. George, I was just saying thank you very much again for speaking with us this morning, and thank you very much for the education.
It's always a pleasure, Marlon. And, the reason why we love, participating in these discussions, both you and I, is because we know that we try to contribute to the level of, elevating the level of discourse and discussion in our nation. Yeah. And this is part of our contribution to nation building because, we are a land of humor, rumor, and old talk and bacchanal. But sometimes we need to have serious discussions and serious issues. And that's why I always appreciate the opportunity to share my thoughts with you and with the nation.
Absolutely, Mr. George. We do appreciate you. Thank you very much again.